Hello and welcome. I'm Amitan Shira and you're watching Law of the Land on Rajya Sabha TV. Today we bring to you the recently promulgated Land Ordinance named the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Amendment Ordinance 2015. To discuss the issue, I have with me Mr. N.C. Saxena, former Rural Development Secretary and former member NAC, and Mr. Krishnabir Chaudhary, President, Bharatiya Krishan Samaj. The land ordinance promulgated by the President recently says that the government can acquire land if it is for defence, rural infrastructure, affordable housing, industrial corridors set up by the government and infrastructure projects. For such acquisition, no consent from land-owning population will be required.
The right to fair compensation and transparency in land acquisition, Rehabilitation and Resettlement Amendment Ordinance 2015, promulgated by President, has done away with the mandatory consent clauses and social impact assessment. The mandatory clause and consent will not be required for land being acquired for the government purposes.
सोशल इम्पैक्ट वाली जो बात है उसमें बहुत सारी बातें प्रभावित होती है जो सामने आती हैं। जैसे मजदूर कहाँ जाएगा, किसान की ज़मीन जाएगी तो उसको बाकी ज़मीन मिलेगी कि नहीं मिलेगी, कहीं रहने का ठिकाना रहेगा कि नहीं रहेगा। और इसलिए एसआईए को भी उसके अंदर शामिल रखना चाहिए। सभी प्रकार के भूमि अधिग्रहण, चाहे वो इंडस्ट्रियल एरिया वाले करें, इंडस्ट्रीज करें, चाहे सरकार करे या कोई करे।
The land ordinance relaxes projects relating to defence, rural infrastructure, affordable housing, industrial corridors and few specified infra projects from mandatory clauses mentioned in the existing law. The ordinance exempts these projects from obtaining consent of 80% of landowners if the project is meant for private purposes and 70% of owners' consent for the public-private partnership projects. The ordinance also exempts them from social impactment and assessment limitations on acquiring agricultural and multi-crop land. In order to have a safety check, the ordinance mandates the government to issue notification before exempting a project from the social impact assessment and limits on acquiring agricultural and multi-crop land.
In terms of land use, because there is an anxiety that you take my land for, let us say, development of road, but you may not use it and you may develop something else there, so the land user will feel cheated, and he has good reasons, and the government will have good reasons to say that I have to change land use because of some change of circumstances.
The Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Ordinance 2015 was promulgated on 3rd April 2015. The ordinance amends the Right to Fair Compensation and Transparency in Land Acquisition, Rehabilitation and Resettlement Act 2013. It also regulates the acquisition of land for public purposes. Government has promulgated the second ordinance on land acquisition to show its firmness on the matter. The ordinance has to get the nod of the Parliament to become a full-fledged act. With camera person Smriti, I am Rajkamal Rao, Rajya Sabha TV.
The ordinance removes the requirement for mandatory social impact assessment study for these key sectors involving public hearing procedures that industries say would have dragged on the acquisition process for years. My question straight away to you, sir, is how has the ordinance actually managed to get in the private sector and the PPP model and exempted these two from the 80% consent clause?
In fact, because the word uses infrastructure, which is very vague and general, it means that for all projects which involve private sector and public-private partnership, there will be no consent and there will be no social impact assessment, which is unfortunate because at least for them, the Act had provided for consent. I would even say that except for security purposes, even when government acquires land, it should be with the consent of the farmers. We should try to see that maximum benefit goes to the farmers and the indirect cost which are incurred because of money going to politicians, mafia gangs or uncertainty, delays, that is reduced. Unfortunately, even in the 2013 Act, there were a large number of flaws which have not been addressed. You have set up a large number of committees. One doesn't know, in case of dissent within the committee, whose voice will prevail. These committees will take years before anything can be decided. Then because generally what happens is government acquires land, it goes from A to B to C. We had suggested that whenever there is escalation, capital appreciation, then the difference, 20% of that difference must go to the original landowner. That has not been done. And also the whole idea of private sector getting plenty of land when they need only little amount of land should have been addressed by saying that unutilized land would be taxed very heavily. That has also not been done.
Krishnabirji, do you feel cheated?
Yeah, it's openly cheated, because in 2013, before finalizing that act, FICCI was asking for 50% consent for PPP model. Then
Reduction from 80 to 50.
Reduction from 80 to 80 and 70. Right. There was a 80 for private, and for PP 70. They were asking for 50%. What is the compulsion before the government? There is no shortage of land. Already we have 550,000 square kilometer non-agricultural land in the country. I have one question. The finance minister everybody is discussing that 30 crore people will get employment. I ask, out of that SEZ policy, only less than 7 lakh people can get employment, and 1,84,000 crores revenue lost beared by this country.
Because of the farmers' land being taken away and the land not being able to be used.
Farmer always cooperate to the government for public purpose, public interest. You ask land for road, you ask land for irrigation project, you ask for power project, you ask for any project which is formed and framed by personnel from government, not in private sector.
What you're saying is that the farmer has been completely taken for a ride, but who stands to benefit is what we need you to answer categorically and crystal clearly.
Only the corporate will benefit without consent of land. Why the government is not ready to ask consent from farmer? What is the difference between 1894 Act and now in the present Act? 1894 Act was the same. There was no need of consent, and government is always informing to the country that farmer will get four times compensation. No, it's a wrong.
Even the corporates will not benefit, because what happens is when farmers' consent is not taken and they are not happy, they will go to the court.
Correct.
And therefore there will be delays. So in that situation, no one benefits. It's a lose-lose situation. See, we must remember 2 points about land acquisition. One is that in any project, cost of land forms not even 1% of the project, which means that if I take 5% of money of the total project cost from a corporate and say this will go directly to farmers, farmers would be more than thrilled. They will be very happy. And secondly, as everyone knows, when land use changes from agriculture to non-agriculture, more jobs are created. So let us make it a win-win situation. Today the model is let some people lose out, let farmers lose out so that others can benefit, which is not good, which is not ethical, which is not even practical, because no one would benefit if there are a large number of court cases. Only advocates will benefit.
Do you see a conflict happening in the near future if this ordinance really carries on? Because, I mean, as Sir said, that even the corporates will not be able to acquire land, because anyone's land that is being acquired in public interest, so to say, will be open to challenging.
Yes, it will be challenged that peaceful development is not possible. Few people are misguiding the government to the Prime Minister. I have great respect for Prime Minister, but I request to Prime Minister that there will be no peace in the country after implementing this act. Why you are not asking to cooperate? Farmer also need the development in rural area. They are also waiting for the employment in rural area. But you have to make dialogue with the farming community all over the country.
Time for us to head into a break. When we come back, we will talk about the change of definition from private companies to private entities. Welcome back. The ordinance changes the existing law under which land could be acquired for the private companies. It replaces the word private companies for private entities. A private entity is defined as any entity other than a government entity.
Ordinance has changed the definition of private company to private entity. All government entities including proprietorship, partnership, company, corporation, non-profit organization and other entity under any law qualify for the purpose of acquisition. The existing law says that if a land is acquired under it, it remained unutilized for 5 years, it be returned to the original landowners or the land bank. The ordinance states that the period after which unutilized land will need to be returned, the return will have to be effected either after 5 years of non-utilization or a period specified at the time of setting up of the project. All the provisions of the ordinance apply retrospectively except for projects initiated according to 1894 Act and 2013 Act, where acquisition was held up due to court orders.
Land is acquired for, let us say, a company or a project. But the project cannot acquire land, cannot influence land use beyond the project area. But in real life, the land use is definitely affected by the land which is beyond the project area is also affected by the project.
The ordinance mandates public servants to take prior approval from government before taking any decision or action. This change has been made to correct the provision mentioned in the existing law. The law states that if an offence was committed by the government, the head of the department would be deemed guilty unless he could show that offence was committed without his knowledge or that he had exercised due diligence to prevent the offence.
पिछली बार भी जो संसदीय समिति बनी थी उसके अंदर हमने सुमित्रा ताई को और बाकी सांसदों को भी कहा था कि किसानों को अपनी जमीन का मालिकाना हक बना रहे और अपनी जमीन लीज पर देने का अधिकार मिले। अब निश्चित तौर पर लीज पर देने का अधिकार मिलने के बाद में कुछ कानूनी परिवर्तन करने पड़ेंगे जिससे लोन वगैरह मिलने में बाकी सारी सुविधाएं हो या आगे निरंतर जारी रहेगी कि नहीं रहेगी लीज खत्म होने के बाद, तो वो क्लास जोड़े जा सकते हैं।
The ordinance mandates that employment be provided to at least one member of a family from farm laborers as part of the R&R entitlements provided under the Act. It also requires that the government conduct a survey of wasteland and maintain a record of the land. The land ordinance has exempted the National Highways Act 1956, the Railway Act 1989 from its purview. The ordinance brought the compensation, rehabilitation and resettlement provisions of these 18 consequences laws under the Act. It has also mandated the Land Acquisition, Rehabilitation and Resettlement Authority established under the 2013 Act to conduct hearings in the district headquarters where land is proposed to be acquired or has already been acquired. Farmers associations in the country have been opposing to several provisions in the ordinance. Government may have to consider their queries before passing the ordinance on the floor of the House. With camera person Smriti, Rajkamal Rao, Rajya Sabha TV.
Besides, the farmer who are obviously upset about the consent clause being lifted, some legal experts are of the view that despite the compensation clause remaining the same, the crucial issue of land being undervalued will continue to persist. That brings us to the question of land rates, the capital appreciation.
Right. In fact, today the circle rate is very low. So therefore, saying that you will get twice the circle rate does not make farmers happy. Market rate is very high. Therefore, easier solution would have been that, okay, whatever is your production today, we will give you double or 3 times of that. That would have been much better solution than providing for circle rate. The other point is, in government acquisition, there is no clause that you can give more than the circle rate or double the circle rate. So the compensation is fixed. What is the purpose of doing social impact assessment if the rate which the farmers are going to get is fixed? So therefore, there is no question of any dialogue. Dialogue will does not take place. So therefore, it is, as I said, the cost of land is very small as the cost of the project, and therefore it would have been much better if the farmers were made happy and land was being given to industry or entity as early as possible, so that there is no delay, there is no cost escalation, there is no uncertainty. Those were the indirect costs which should have been reduced, and direct benefit to farmers should have increased.
Krishnabirji, you want to add something to what sir has said?
Government should make the arrangement that farmers should be shareholder in the development, and if the government needs the land, he should get the 1/3 part of the developed land. That will also use for the development of industrial.
Was that available in 2013?
It's only 20%. It's not suitable. It should be minimum 1/3.
Is that addressed in the ordinance, or has the government indicated any intention of listening to the point of view that you're raising here, that 30% developed land should be repatriated to the farmer?
Yes, because that land will also use for industrial development.
No, I understand, but is there any indication?
Ordinance is silent.
It's silent. It's not open. It's a silent. Government is silent on this side.
So the government is silent. So basically, the 2013, which is the principal act,
yes,
there were problems in it, as sir mentioned.
Yes.
Those problems have not been addressed.
No.
In fact, the certain aspects which were considered to be good in that principal law have been further diluted.
Yes.
And now the farmer stands to be completely deserted, and they're going to be a rural conflict.
But the only good point in the ordinance is that there are 13 other land acquisition laws, like the Railways Act or Coal Bearing Act or National Highways Act.
That has been synergized.
They have been included here. So therefore, rehabilitation under those acts will now follow what is given in rehabilitation clauses in the 2013 Act, which is a good thing. So that's a good point.
And sir, the categorization of land, for example, land acquisition, the 3 points, the priority that the government has set, which means priority number 1, acquisition, government land will be preferred. Second, it will be non-irrigated, and third, it will be
This is only for
Does it make sense?
No, it makes no sense at all. A collector or any SDM will certify that there is no wasteland available, there is no unirrigated land available. So therefore, that doesn't make. That is only to satisfy the press. Otherwise, it makes no. In actual practice, it makes no difference. Government is still free to acquire any land that they want.
Kashmirji?
Maximum land in the country, as per the revenue record, it has not been described as a multi-crop land. This is a big fault. And why the government is not going to consult and to make the confidence with the farmers and the industry? Government should try that there should be farmer should be ready. Farmer is ready everywhere to share in the development. But forcefully, it's not possible. It's a culture of the rural farming community that if you ask with a proper respect that we need this for the development of the country, he will share, he will help the government. If you will try to forcefully acquire the land, then there will be no peaceful development. This is my personal opinion. It's an experience of my life in whole of the country, and government should not make any forceful attempt on the farming community.
Sir had made a passing mention of the voice in the committee. Whose voice? While the land is being acquired, there's a committee at the district level, and there are going to be all kinds of parties. Now, the law doesn't clarify which voice will prevail as far as acquisition is concerned. So, in absence of that, he made a passing reference of it, but I want to understand it more clearly. What is going to be the implication?
No, there is another point.
Yeah.
See, under the 1894 Act, all powers were delegated to the collector. Collector could acquire land. Now, under the 2013 Act, there is no such delegation. Everything will have to go to government, which means even if you want to acquire 100 square meters of land for some linear project, it will have to go to the Chief Secretary. And it will pass through social impact assessment, expert committee report, Chief Secretary's report, committee, monitoring committee. How many committees are you going to set up? So therefore, no acquisition can take place even under the ordinance, because there is no delegation to the collector. At least for up to 100 hectares, there should have been complete delegation to the district. That is missing in the law.
So even that has not been addressed.
Not at all.
Makes it more difficult to acquire.
Yes.
On the voice in the committee, whose voice will prevail? There are going to be two parties.
Only the government voice will be there, and farmer cannot ask for his judicial right directly without permission of that committee or without permission of the government.
So what you are saying is
the legal right.
So if the farmer's land is being acquired,
yes,
the farmer will have to seek permission from the committee
yes,
to go to the
yes,
High Court or
yes,
the lower court.
Yes. without permission, he cannot go. They called it, it's a government committee. What is the use of this government committee? In previous 1894 Act also, there was on behalf of DM, ADM Finance was the land acquisition officer, special land acquisition officer, then SDM, then Tehsildar, then lower level, and just DM called to the farmers, few farmers, and consult that we are going to develop this area and we need land this. Again, same problem.
So one last point that I want you to address is, there was a clause that after 5 years of non-utilization, the land would automatically fall back into the farmer's hand. Now there is another significant addition to it. They have said that while acquisition, if there is a date mentioned in the acquisition, that or the 5-year, whichever falls the latest, I mean which is the later of the two, will be considered for repatriation of land.
This is again with the view to dilute the intention. Intention was that if you have not acquired, if you have not used land for 5 years, it must go back to the farmer. And at the same time, there should have been a provision that after 3 years, if you're not utilizing the land for the purpose that you had indicated, there should have been tax. And taxation should have increased with every year. That has not been done. So we must try to discourage this tendency of acquiring a lot of land when only little is needed. And because land is not going back to the farmer, again there will be a tendency to acquire 100 times or 10 times the land that you need.
That's all we have time for, Krishna.
That's the only point.
Moving on.
For affordable house, government have not defined what will be the definition of affordable house. Which builder is telling that I am not constructing affordable house? Is it for BPL card holder?
Krishna Birji, thank you very much. Moving on, my colleague Raj Kamal Rao spoke to Mr. Sanjay Upadhyay, founder, Enviro legal firm, and tried to get his perspective.
This government obviously is going in a big way to ease business, never mind the other concerns. But there are 2 or 3 points that comes to my mind. I'm not a huge expert on mining laws, but certainly 2 or 3 points come to my mind which I think are crucial. One is this whole 2-stage process that has been reduced to 1 in terms of the area itself. Now earlier, if you recall, there was a 10 square kilometer area, and then whatever you needed for ancillary activities you could then apply. So there was more definitive requirement, and according to that requirement the area was to be given. Now it's a blanket thing. You can have a 10 kilometer, 12, 14, 15, you can ask for 20, we do not know. So there's absolutely lack of clarity on the area itself. I think that is a crucial question. The other is when you are depositing royalty in a, let's say, a district fund or whatever has been created, there the real issue is that the area which ordinarily goes for mining is not just a state versus a private party, but there are a lot of people who are dependent on that. People may have rights, people may have usufruct rights, and there are a lot of dependence on it. Now today there is no mechanism to prioritize how this fund will be utilized. So there is absolutely again state versus the private party, and there is no participation of people who are actually affected, who may be affected in that area. So I think prioritization is important. If you recall even the Samata judgment earlier, or even the Balco judgment, and later the Periphery Development Fund concept in Orissa, for example, there was some mechanism of how to decide priorities of fund utilization. I don't think that is clear in this bill, if I understand it correctly. The third thing that comes to my mind is this whole MOEF OM now, which talks about renewal of mining lease versus environmental clearance. That if you have an environmental clearance that subsists, then there is no need for a fresh environmental clearance. Now my problem there is that for a long-term lease on mining, situations change after 30 years, 35 years, 40 years. And therefore, any renewal has to take into a fresh environmental context. There are fresh environmental contexts that you need to consider. I don't think that is prescribed anywhere, neither in this bill nor in the EIA process, except there is an OM now. To my mind, that is, from the environmental standpoint, that's a huge risk that we are taking. And I think any renewal has to go through an EC process, an environmental clearance process, afresh, because situations have changed in the last 30, 40 years when the mining lease actually expires.
Thank you, sir, for joining us on this discussion.